So, good morning, everyone. Delighted to welcome you to the Burners Paul 2021 Third Sector Conference. This is the last session of a series of 5 online sessions which have taken place every morning this week. The theme of this year's conference is resilience. How can third sector organisations future-proof their organisations to protect against the uncertainty of the future? This morning, we're joined by my colleague, Morag Hutchison, famous for her 2 pence, 2p joke, but I'm sure she'll have a new one this year. No pressure, Morag, who's a partner in our employment team, and she's going to cover some employment law developments in the past 12 months and also highlight some future developments that it is important for the sector to be aware of. So I'll hand you over to Morag.
I feel like I'm going to disappoint everyone now, Graham, because I don't have an employment law joke for the session this morning. I only have 2 jokes. The Choopy joke, which many people in the session will have heard many times, and my funfair dismissal joke, which I think I've also told. So yeah, I need to expand my repertoire. Good morning, everyone. Thanks for joining the session this morning. What I'm going to do, as Graham said, is kind of cover some of the key cases over the last 12 months and then also look forward and some kind of key developments in employment law that are coming down the line. So I'm going to split it into 3 parts, if you like. Firstly, I'm going to look at some case law. I'm then going to look at just some news items to cover off, and then finally I'm going to look at developments as a result of case law and legislation to be aware of. In relation to the cases, I've got 8 cases for you today, so I'll go through them as quickly as I possibly can. I've got a case on employment status. You'll all have seen it in the headlines, the Uber case. I'm just going to touch on that very briefly. I'm then going to look at a redundancy case, which is all to do with whether the motive behind the redundancy is something that a tribunal can take into account or not. I've then got 3 disciplinary cases for you. All very positive stuff, isn't it? The first one is on an employee who undertook surveillance of his colleagues and whether that was allowed. The second one is a dismissal for refusing to wear a face mask, which I thought was probably very topical, given the circumstances we're currently working in. And then the third one is a dismissal in connection with trade union activities. So for those of you that work in a unionised environment, I think it's quite an important case to be aware of. And then I'm going to look at a couple of discrimination cases. One is about the reasonable steps defence in a discrimination claim, and it's quite an important decision that's come out in the last few weeks actually to put on your radar. And another is around about where an employer takes action and they think they're doing it for a good reason, can they still end up with a discrimination claim? And then finally, on tribunal process, I'm going to look at the issue of whether or not individual employees can be required to disclose information from their personal phone or their personal social media devices and accounts. So I think that's quite an interesting one too. So that's the cases we're going to look at, and then, as I say, we'll go on to look at some news items and then a bit of an update on legislation and cases that are coming down the track for us. So without further ado, let's very briefly just look at the employment status case. I just wanted to flag it. I think it shows a real direction of travel in terms of where employment law is going in the UK. You'll all have seen, as I say, in the news, the Uber decision. It came out a couple of weeks ago. It was a Supreme Court decision. So this is a case that's been rumbling on for quite some time. I think it goes back to 2017. And now we've finally got a Supreme Court decision, so a final decision in relation to employment status. It was the whole question of whether Uber drivers were genuinely self-employed or whether they were actually workers. And the reason why that is such an important question for the Uber drivers is if you're a worker, then you're entitled to holiday pay, and you're also subject to the working time regulations as well, which means that you're entitled to national minimum wage. So it was this whole question of were these individuals genuinely self-employed or did they have worker status? And ultimately the Supreme Court has held that they do have worker status. And I think, as I say, it kind of demonstrates the direction of travel that a lot of employment law is going in. There's this whole issue about gig economy and a whole swathe of individuals who don't have any rights within the workplace. And that was really what was driving this case going all the way to the Supreme Court. And just very briefly, the kind of factors that the Supreme Court took into account when they were deciding the status of the Uber drivers included the fact that they had no relationship really with the passenger at all. So the passenger would contact Uber. Uber would put them in touch with the driver. The driver would then have no details of the passenger when they got in the car. The driver wouldn't ask the passenger to pay any payment. That was all done through Uber as well. And so although there was an invoice kind of issued which looked as if it was from the driver to the individual, the reality was there was no relationship between the driver and the individual at all. It was all driven, pardon the pun, it was all driven by Uber. Uber also effectively told the driver what route they were to follow. Now, the driver could choose not to follow that route, but if they didn't follow the route, then they could be marked down on the sort of Uber I suppose records of all of the drivers. And also if they had poor feedback from the customer, Uber could use that as a basis to terminate their contract. So there was quite an element of control over how the driver actually performed their duties. And I think the kind of key point in the case is what the Supreme Court made very clear is no matter what your contract says, so no matter that you have a contract in place that says this individual is a self-employed consultant, the courts will look beyond what is in the contract and will look at what actually happens in practice. And so it's just to flag to you, for those of you that do have relationships with self-employed consultants, you know, absolutely spend time putting your contracts together to try and protect your position as much as possible. But the courts will look at what happens in reality. So they'll look beyond the contract itself. So just something to be aware of. So that's employment status. The next one I want to look at is the case of, and I should say, sorry, I've got a list of all of these cases as well, which we can circulate after the session. But the next one I want to look at is this redundancy case, which I think, I always start these cases with, I think it's a really interesting one, but I do think it's an interesting case because the background to this case is a Berkeley Catering Limited against Jackson. The claimant in this case was the managing director of a catering company, and the company was owned by Mr. Patel, who previously had been the managing director. So over time, Mr. Patel started to kind of come back into the company, take a more active role in the business again, and there was quite a bit of animosity, I guess, between him and the claimant. And what he decided to do then was set up a new position of Chief Executive Officer, which he took over. He had a much more active role in the business and decided to become Chief Executive Officer. And when he implemented that new role, he then said that the role of Managing Director was redundant because there was no need for a CEO and an MD. And so the claimant, Mrs. Jackson, was made redundant on that basis. Now, what Mrs. Jackson argued in tribunal, and she succeeded in the employment tribunal, is that there was no genuine redundancy situation. The definition of a redundancy is where there's a diminution in the requirement for work to be carried out. And what she said was there was no diminution in the requirement for the work to be carried out. The real reason why my role was made redundant was because Mr. Patel wanted to come back into the organisation and take it back over. We had a very difficult relationship and he just dressed this up as a redundancy in order to exit me from the business. And the employment tribunal accepted that and said it was an unfair dismissal. That was then appealed to the Employment Appeal Tribunal, and the Employment Appeal Tribunal overturned that decision, which I think is quite surprising. And what they said was the motive behind a redundancy is not relevant. What you have to look at is, was there a redundancy situation? And they were prepared to accept in this case that because this new role of CEO had been created, there was no longer a requirement for the role of managing director, and therefore it was a genuine redundancy situation. As I say, I think that's quite a surprising decision. It's an employer-friendly decision, but quite a surprising one, I think. So just an interesting one to have on your radar. On discipline, I said we had 3 cases on disciplinary issues. The first one is this kind of question of whether or not an employee can carry out surveillance on their colleagues. So this is a case of North Bay Pelagic Limited against Anderson. So in this case, Mr. Anderson was a director of the company, and he decided to set up a camera in his office to monitor whether anyone was accessing his computer when he wasn't in his office. Now, he had become suspicious that someone had entered his office and had accessed his computer, and that is why he set up the camera. Needless to say, the relationship in this case had broken down a bit between employer and employee, and he was in a position where he felt that there was a lack of trust and there was a bit of a relationship breakdown there. So his employer discovered that he'd set up a camera and hadn't told anybody, and they took disciplinary action against him for doing so, and they dismissed him on the grounds of gross misconduct. And so the question for the tribunal was it reasonable to dismiss an employee for carrying out covert monitoring on their colleagues, obviously without letting their employees know that they were, or their colleagues know that they were doing that? And the Employment Appeal Tribunal's decision in this case was that the employee's conduct in putting up this camera was not conduct that justified dismissal on the grounds of gross misconduct. And what they said is the employer really had to balance the kind of the right to privacy that employees have against, in this case, the claimant's wish to protect his confidential information. And what they took into account was the fact that the camera was set up in the claimant's office, and that was his office. He was the only person that had a key to the office. It wasn't a public area. And so they felt that when you balance those interests up, the fact that it was his own private office and he hadn't set up the camera in a place where there was a lot of traffic or a public place, and also the fact they took into account the fact that nobody was actually captured on the camera, and so therefore, in their view, there wasn't sufficient grounds to dismiss on the grounds of gross misconduct. Again, I think that's quite a surprising decision. Obviously, it's based on the particular facts in the case, but I think it's a surprising decision that an employee is able to set up covert monitoring without telling their employer, and it's not grounds for gross misconduct. What the EAT did go on to say was if you want to dismiss an employee because they've set up covert monitoring, then what you should really do is include that, as many of you will be familiar with, in your disciplinary policy. You'll have a list of things that would be viewed as gross misconduct, and you should really make it very clear within your own disciplinary policy that covert monitoring could be viewed as sufficient grounds for dismissal for gross misconduct. So again, an interesting case. The next one I want to cover with you is this case of dismissal for refusing to wear a face mask. We're starting to see now quite a few cases come through the tribunal where there's an element of, or it's COVID related in some way. And this case here is an interesting one as well. It's Cubilis against Kent Foods Limited. And in this case, Mr. Cubilis was a delivery driver. He worked for Kent Foods, and one of their key clients was Tate and Lyle. And so his role was to deliver product into Tate and Lyle and come back out of their premises. Now, his employer's handbook required employees to show courteous treatment towards their clients. It also said that employees should take all reasonable steps to safeguard their own health and safety and the health and safety of others whilst at work. And the handbook also stated that employees were required to follow customer instructions when it came to PPE and the obligations to comply with health and safety rules of particular clients. And Tate and Lyle had introduced a rule that all drivers, anybody on their site, were required to wear a face mask at all times. So Mr. Cubilis drove to the Tate and Lyle site to do a delivery. This was back in May last year. And he didn't have his mask on. And he was asked repeatedly by a Tate and Lyle employee to put the mask on. It was explained to him that the concern is because he was sitting high up within the cab of his lorry. If he didn't have a mask on, droplets could be released down towards people that he was speaking to when he opened the window or when he opened the door, and therefore they required him to wear a face mask at all times. He refused to do so, and so Tate and Lyle then reported the incident to his employer, and they banned him from the site. His employer then tried to persuade Tate and Lyle to allow him back on site, which they refused to do. They then looked to see whether they had any alternative roles within the organisation, because his key role was driving back and forward to the Tate and Lyle site, but there was no other vacancies. So they dismissed him on the grounds of misconduct for failing to comply with a reasonable instruction. And the tribunal held in that case that it was reasonable to dismiss the employee. And the factors they took into account there were the fact that there was very clear rules in place. The employer had very clear rules in place that said you had to show courteous treatment to clients, you had to take reasonable steps to prevent health and safety, and you had to follow their PPE instructions. What the tribunal did say, though, was it would not always be reasonable to dismiss an employee for refusing to wear a face mask. And you'll not be surprised to hear that what they said was it very much depends on the facts and circumstances of the case. It depends on the role that the individual is playing, and whether or not you can show that there's reasonable grounds to insist on an employee wearing a face mask at work. So again, just to, I suppose, flag that case to you, some of you will absolutely be in environments where it's very important that you do insist your employees are wearing face masks at work whilst the pandemic is ongoing. For others, it may be a preference but not a requirement. So just to be aware, you need to take that into account when you're deciding whether or not you're going to take any action against an employee if they refuse to wear a face mask at work. And again, I guess one of the kind of key lessons from that case is having those very clear rules in place so that an employer could point to them and say, well, you knew in terms of our rules, you were required to show courteous treatment to Tate and Lyle, you were required to take steps to protect health and safety, etc. So I think another interesting case from a disciplinary point of view. The next one I wanted to cover was this case to do with whether or not somebody's action or dismissal was related to trade union activity. So some of you will be aware that there's a right within the Employment Rights Act that an employee shouldn't suffer a detriment by any act or omission of the employer that has the sole purpose of preventing or deterring the employee from being a member of a trade union, taking part in trade union activities, or penalises them to do so. So if an employee is in any way treated detrimentally because of their trade union activity, they have particular protection under the Employment Rights Act. And so in this case, it's the University College London against Brown. The university had a circulation list, if you like, or an email list of employees that they used to send out information all the time. And when they had a look at the list itself was actually very out of date. It also meant that they were sending, it was within the technology team within the university, this list, and they were sending information to employees who were no longer in the technology team, or they were sending information to employees that was completely irrelevant to them. And they'd had quite a few complaints about the volume of information that was being sent to them because they were on that email list. However, the union within the university also used that particular list in order to communicate with its members. So the university decided to remove that list and to create a new, much more focused list for the purposes of their communication. The claimant in this case was unhappy about that because he was a trade union representative and they used the list to communicate with their trade union members. And so he decided to set the list back up again and started using the list again. And his employer asked him to remove it, which he refused to do. And so they disciplined him and they dismissed him for failure to follow a reasonable instruction. So they dismissed him for misconduct. And he argued that the primary reason for his dismissal was connected to his trade union activities. And so the question for the tribunal in that case was he dismissed for misconduct, failure to follow a reasonable instruction, or was he dismissed because of something connected to his trade union activities? And it's quite a thin line there, I think. But ultimately, the Employment Appeal Tribunal took the view that the kind of main reason, or the sole reason behind the employee being dismissed, was because it related to his engagement with union activities. So the fact that he had set that list back up in order to enable him to continue to communicate with his members, the EAT's view was that meant that the kind of main reason for his dismissal was his trade union activities, and so it was held to be an unfair dismissal. So again, it's just thinking about, for those of you that work within a unionised environment, if you're taking action against an individual who's a trade union representative, being very careful to consider, well, is that action because of their trade union role, or would we be taking that action anyway, irrespective of their trade union role? And sometimes it's quite difficult, to draw that distinction. A couple of discrimination cases. The first one is the case of Ali UK Limited against Galen. This is a really important decision that came out, as I say, a few weeks ago. Where you have a claim of discrimination against your organisation, An employer can defend that claim if they can show that they've taken all reasonable steps to try and prevent the harassment from taking place in the workplace. And one of the key bits of evidence that employers lead to show that they've taken reasonable steps to prevent harassment in the workplace is to demonstrate that they've trained their staff, their staff have gone through some sort of equality and diversity training. So in this case, what happened was the employer had provided training to staff 2 years before on equality and diversity in the workplace. A colleague had made an inappropriate comment to another colleague based on their race, and that the individual who made the comment had attended the training 2 years ago. The tribunal took the decision that the employer, notwithstanding the fact that the employer had carried out equality and diversity training, they couldn't avail themselves of the reasonable steps defence, because the evidence that they took into account was the fact that the colleague who made the comment had been on the training himself 2 years ago and viewed the comment as just banter and not discriminatory. So they said, well, it kind of questions the effectiveness of the training that was provided. The other factor they took into account was that the individual's line managers were both aware of the comments that had been made, but took no action, and they had both been on the training as well. And what the tribunal said was it would have been reasonable for line managers in that situation to think, well, hold on, we had training on this a couple of years ago, this isn't appropriate. Obviously, the individual isn't aware of that. We should really be looking at refreshing the training. So the key point that came out of that decision really is, and it's an important point, I think, for employers, you may all have made sure that you've gone through training with your staff in relation to equality and diversity. But you need to take into account how often you should be refreshing that training. It's not enough just to run it once and then forget about it. You're not going to be able to rely on the reasonable steps defence if the tribunal take the view that, yes, you've provided training, but it wasn't very effective, as demonstrated by what's happened within the organisation, and you really should have been looking at refreshing it. So again, another interesting decision, I think. Conscious of time, I'm also conscious I'm speaking very quickly, so apologies, but just to make sure I get through all of these for you. The last case on discrimination is the case of Chief Constable of Devon and Cornwall Police against Town. And as I said at the beginning, the interesting point in this case is, even if the employer has done something because they think it's a good thing to do, that won't avoid the risk of a discrimination claim. Let me put that in context for you by explaining the facts in this case. So the claimant in this case is a police officer, and she was pregnant, and so her employer carried out a risk assessment. She's a frontline police officer, and they carried out a risk assessment, and they decided that she could remain within her existing team as long as she was her frontline duties were restricted. And so that was the outcome of the risk assessment in relation to her pregnancy. However, the police force had a policy that said if officers were put on restricted duties for any reason, they had to be moved to a crime management hub, which was effectively back office duties. And so Mrs. Town, notwithstanding the fact that the risk assessment, the outcome of the risk assessment was that she could remain with her existing team, she would just have to limit some of her duties, she was moved into this crime management hub. And she was really unhappy about that because she wanted to work with her team. She was moved to another team, and as a result of that, she suffered depression, and it had an impact on her health, and so she suffered a detriment. So she made a complaint and raised a sex discrimination claim on the basis that she had been treated less favourably because of her pregnancy. And what the police force tried to argue in that case was, but we were moving her, the reason why we moved her to the crime management hub, there was good intention behind it. We were seeking to protect her during her pregnancy before she went off on maternity leave. And what the employment tribunal said in that case was, your kind of good intentions, police force, are not a defence to the decision to move the employee. You carried out a risk assessment. You were told that she could remain within her existing team if you limited her duties. Notwithstanding that, you moved her anyway to the crime management hub against her wishes. And the reason you did that was her pregnancy. Therefore, it's direct discrimination. So again, it's just to think about in practice, if you're dealing with situations like that within your own organisations where you've got a pregnant employee, perhaps who's on some sort of frontline role, and you're concerned about their health and safety, ensuring that you do that risk assessment is obviously very important. but also ensuring that you then act on the risk assessment, and you don't, even if you are trying to do what you think is the right thing, you don't make too many assumptions about what is the right thing for that individual, because even when you think you're trying to do the right thing, you can still end up with a discrimination claim. The last case I wanted to cover is, as I say, on personal devices, whether you have to disclose information on personal devices. This isn't an employment case, but the reason that I want to refer to it is it is something that comes up more and more often in the context of employment tribunal claims. It was a case actually by it's Phones for You Limited against EE Limited and others. When Phones for You Limited went into administration, they took the view that other phone companies were working together in order to basically get them put them out of business by anti-competitive behaviour. And what they said to the court was, we believe that employees of EE and other organisations were using their personal phones in order to carry out that conduct in the background that ultimately led to Phones for You going into administration. And therefore, as well as the company's phone records and email accounts, we want access to the individual's private emails and private phone accounts. And just very briefly, the kind of decision from the court, obviously there was an argument that that was against their human rights, it was against their right to privacy. How do you separate what's private from what's work related within your private phone? You can't pull the two things out, so employees shouldn't have to disclose everything. But ultimately what the Court of Appeal said in that case was, again, you have to balance the rights of an individual's privacy against the need for courts to get to the nub of the issue and to get to the real evidence in an issue. And the court was prepared to issue an order requiring EE and the other companies to contact their employees and ask their employees to provide that private information. And as I say, it is something that we see come up more and more often, where employees are kind of wise to the fact that sometimes employers will use private WhatsApp groups or whatever in order to discuss situations rather than put it on work email. And for those of you that are trustees of charities as well, as I am, you need to be careful when you're using your own private account for charity business. Potentially that can be disclosed, or it can be disclosed as part of subject access requests as well. So just to put that one on your radar. I'm full of good news. I'm full of good news today. Right, that's the case update. Very briefly, I'm going to cover some news points. I just wanted to mention Brexit, the extent to which it's likely to impact on employment law. As part of the deal that was reached just pre-Christmas there, the UK government have an undertaking not to weaken the level of protection that was in place as at the 31st of December 2020 from an employment law perspective. So we're not anticipating a lot of change to employment law initially. It might come over time. I wanted to mention COVID. Obviously, it's highly topical. You'll know that furlough's been extended now to the end of September. The issue that we're advising on a lot just now is whether you can force employees to take COVID tests or force employees to have the vaccine jab. The answer to both of those questions is no as a starting place, but as always with employment law, it will depend. It will depend on the kind of role that the individual is doing. There will be some roles, particularly again within our, the charity sector, where you can see that you have strong reasons to really encourage your employees to have the vaccine. If ultimately they refuse to do so, potentially you can dismiss for failing to follow a reasonable instruction, but you'd have to be able to demonstrate that you had really good grounds why you needed to force effectively the individual to have their vaccine. And you also need to be aware of the potential risks of discrimination claims. If the reason the employee doesn't want the vaccine is because they're pregnant or for religious reasons or any other, any reason connected to disability, etc., then you've potentially got the risk of claims there as well. So just have to be very careful. And the other thing that we're seeing coming up in connection with COVID now increasingly is employees who are suffering from long COVID and how that impacts on how you manage their absence from work. Potentially long COVID would be viewed as a disability, and so having to be very careful in terms of making reasonable adjustments and managing that process very carefully. So I just wanted to mention those. Also, you'll have seen, any of you that have got over 250 staff, gender pay gap reporting has been pushed back, so you don't need to report now until October this year. Finally, upcoming cases and legislation. Of course, we have to mention the MENCAP decision. Many of you I know will be waiting to hear the outcome of that. So this is this question of whether employees who are required to sleep in overnight, whether they should be paid minimum wage for all of those hours, or should they only be paid for the time that they're actually woken and helping service users. The Employment Tribunal and Employment Appeal Tribunal both said that it would be working time for the whole evening, which would cost the sector a huge amount of money. That was overturned by the Court of Appeal. The case was appealed to the Supreme Court, and the hearing took place in February last year. We're still waiting on a decision, but I expect it's imminent. But I did want to flag to you, there was a couple of cases reported in the European Court of Justice last month, which covered exactly this point about whether standby was working time or not. And if, obviously, the Supreme Court has no obligation to follow the European Court of Justice decisions anymore, but if they're minded to take it into account, it is more likely to overturn the Court of Appeal decision and go back to the Employment Tribunal and Employment Appeal Tribunal decision that time spent overnight is working time. What the European Court of Justice said in the cases was, if there are constraints that very significantly affect a worker's ability to devote that time to his or her own interest. So basically what they were saying is, if your leisure time is impacted because of the requirements to be on standby, then that is likely to be working time. So you can see the argument that where you've got people that are sleeping overnight, that absolutely does impact on their leisure time. And so potentially, as I say, if the Supreme Court look at those decisions, there's a real risk that they will overturn the Court of Appeal decision and say that time sleeping in overnight is working time, which obviously will have a major cost implication for the sector. So just putting that one on your radar, that obviously we're still waiting for the decision. The other thing I wanted to cover was there's a new employment bill going through Parliament at the moment, which has some interesting changes to it. I don't know when it's likely to come into force, but the key things are a prohibition against making employees on maternity leave redundant, or making them redundant within 6 months after maternity leave, which will be quite a significant change to employment law in the UK. For people that are on 0 hours contracts, giving them a predictable pattern of work after 26 hours, so effectively giving them a guaranteed number of hours. Also moving towards flexible working being the default. So at the moment, if an employee wants to work flexibly, they have to apply to the employer. The Act contained provisions that would provide that employees by default could work flexibly, and it would be for the employer to change that if it wasn't working for them. So quite a shift in emphasis there. The introduction of carers leave, potentially up to 5 days carers leave, and also the introduction of neonatal leave. So where a child has been born and is in neonatal care, given the mother and father time off during that period to spend with the child. So just various things to be aware of in terms of potential changes. Oh my goodness, I've spoken very quickly at you. I hope that's been helpful. Lots of information. As I say, I'll send you out the case list. And yeah, I hope that's been useful. Thank you.
That's brilliant, Ulrich. Thank you so much. That was a lot covered in the time,
Yes.
but all very interesting. And I'm sure with the employment bill, if people follow you on LinkedIn or they'll be, or subscribe to the blogs, they'll be able to get updates on that when things start to come into force. Yeah. So we just have the one question just now, and it's, are there any employment law updates that are relevant to adequate ventilation in offices and returning to work in employers' premises, and how that would affect kind of obligations on the employer and impact?
Yeah. There's no employment law update. There's no particular kind of proposal to change anything from that point of view. It would come under health and safety anyway, in terms of obligation to provide a safe system of work and a safe place of work. It's certainly quite a hot topic. You know, you are seeing employees increasingly raising concerns about health and safety issues in relation to return to work. And interestingly, this week, the right for an employee to claim detriment as a result of raising a health and safety issue the proposal is to extend that to workers as well this week. There's new legislation going through Parliament on that. So whilst there's no specific change to the law, if you like, dealing with that issue, the route that employees can take is if they're concerned that there's a risk to their health and safety as a result of the ventilation system. If they're then forced to work, notwithstanding that, then potentially they can bring a claim. So yeah, it's a very topical issue.
Yeah, there seems to be a lot to think about just now, and the link to our recent webinar on you mentioned whether you can compel your employees to get the vaccine. There's been a link to that webinar posted in the chat if anybody wants to have a look at that. So I think that's all the questions we've got just now, unless anybody else wants to pop any questions in the chat before we finish up. Just wanted to say thanks, Morag, for doing that. That was very interesting and a lot to be aware of in the next few months. So also just wanted to wrap up and say thanks to everybody for coming along to our third sector conference this year. I know there's a few of you who have been on all, if not some, of the sessions throughout the course of the week. Obviously, our theme was resilience in the third sector, so whether that's working with other organisations to take advantage of synergies, looking at what you can do competently to grow your own income, what you can do to advance employee well-being, which obviously with employees being a massive asset for the organisation is important, and also, as we've heard from Morag, making sure that you're on top of all the employment law issues that are coming out just now and wouldn't probably have been a particular topic this time last year. So I hope that you've been able to take away something that will, at least one thing that will help your organisation continue to move forward in the still difficult months that are most likely to come, even though hopefully, fingers crossed, we're starting to come out the other end of this. But yeah, I might be being a bit too optimistic, but we'll see. So thank you again, everybody, for joining. If you do have any follow-up questions that you think of when you come off and you want to pick up with us, then please just drop us an email. You'll find our contact details on our website if you don't have them already. And if there is anything else you want to follow up from the rest of the week as well, then please feel free to do so. Thanks again for joining and hope to see you all soon.